Welcome to oral arguments in the First District Court of Appeal. We have 3 cases on our docket that will be taken in the order indicated on your dockets, and after the first case, we'll have about a 10-minute break, and most of you are familiar with the attorney's commons to your right. We'll have coffee over there, and lawyers are welcome to join us over there and have a little fellowship. First case is Imagine Insurance versus the Department of Insurance, or what used to be the Department of Insurance, whatever it's called now, Ms. Hauser. Okay. We'll hear from the appellant.
May it please the Court. James McKee of Foley & Lardner on behalf of the appellant, Imagine Insurance Company. I'd like to reserve 5 minutes for rebuttal, please. This case involves primarily the interpretation of a structured reinsurance contract. The trial court below gave an interpretation of the contract that was contrary to both the plain language of the contract and the intent of each of the parties involved in actually negotiating and drafting the contract. Now, the trial court's misinterpretation below and the receiver's attempts to disregard the bargain for terms of the contract threatens to undermine the ability of the reinsurance market to function in the state of Florida and could have serious marketplace ramifications. The contract at issue, again, a structured reinsurance contract, not a traditional reinsurance contract, provided a maximum of $2 million worth of coverage in exchange for $900,000 worth of premium. Because it was a structured reinsurance contract, it also included a profit and loss sharing component. In a storm-free year, such as in 2003, American Superior, the insured in this case, actually entered into the same exact contract in 2003 with a different reinsurance company. In a storm-free year, as in 2003, the contract would only have cost American Superior $270,000 because the additional premium would have been returned to American Superior pursuant to the profit and loss sharing component. In this case, we had an unprecedented storm season in 2004, the time that the contract was in effect, and part of the loss that was incurred by Imagine had to be paid by American Superior. Now, the payment plan under the contract provided that the $900,000 in premium would be paid in 4 installments. However, and importantly, it also provided that any premiums would be deducted from lost payments when they were made. Now, a loss was incurred and a lost payment was made in 2004, again, an unprecedented storm season. The full $2 million loss was incurred by American Superior and was paid by Imagine. Imagine at that point had fulfilled all of its obligations under the contract. The $2 million loss was all that the contract provided for. There was no additional coverage provided. Pursuant to the plain language of the contract provided that any lost payments, quote, shall be offset against any outstanding premium installments due for the contract year. At the time that the loss was incurred in August, there were $630,000 of premiums remaining due for the contract year. Imagine paid out the $2 million, deducted the $630,000 in additional premium due, and remitted payment of $1.37 million to American Superior. This result was consistent both with the plain language of the contract and the understanding of the parties, the actual parties involved in negotiating the contract, American Superior and Benfield. Benfield is a world-recognized, one of the largest reinsurance brokers in the world, and actually negotiated this contract, advised Imagine that it was entitled to set off the $630,000 in additional premiums from the lost payments.
Well, what are we to make of that? Is that really a matter that should influence us? Isn't what we look at the language of the contract? How does the behavior of the parties influence us?
Well, I think, yes. The first place we need to look is the plain language of the contract, and I think the plain language of the contract is clear. When it says that any lost payments shall be offset against outstanding premium installments due for the contract year, I think that has to be interpreted to mean that $630,000 worth of premium installments continue to be due for that contract year. My point in bringing up the intent of the parties is merely to show that, if anything, there are 2 reasonable interpretations. I don't think it can be said that the only interpretation that's reasonable is the one given by the court and urged upon the court by the receiver. And there is evidence in the record from Benfield and from others as to the intent of the parties, and the intent of the parties is contrary to the plain language as interpreted by the trial court. But I believe we don't need to get there, because I believe the plain language is consistent with the interpretation given to the contract by Imagine, by the appellant. Now, one of the arguments raised by the receiver is that the $630,000 in premium was not earned. It was unearned premium, and for some reason is due to be returned to American Superior. That's simply not the case. The principles that are cited by the receiver, consumer insurance principles, apply by statute to consumer insurance contracts, to automobile insurance contracts, homeowners insurance contracts. In that type of a contract, if you have a loss on day one, you can recover up to your policy limits, and have a loss on day two and recover the same policy limits. This contract, by its plain terms, was not that type of a contract, and you cannot apply consumer insurance principles.
To what extent does the state of Florida regulate reinsurance?
Well, there are regulations in place, but as applies to earned premium or unearned premium or any definitions there too, I don't believe there are any regulations in place.
Do they regulate the terms of the reinsurance contract?
Not in this respect. They do in other respects, but I couldn't give you particulars on how. But as to the definition of earned premium or unearned premium, I do not believe there are any regulations in place. It's important to look to the definition of what earned.
So the contract here, I'm not sure it says this, it could have said the premium, all of the premium for the year is earned on day one of the contract, if it had chosen to do so.
I believe it could have. I think you have to give, and the court's duty, I believe here, is to give effect to the actual terms of the agreement. So long as the terms were negotiated between sophisticated parties, as they were here, with a sophisticated intermediary acting on behalf of American Superior, I don't believe it's up to the court to reinterpret the contract or rewrite the contract. I think the contract has to be given its clear terms. And in this case, I think it's clear that the premium was earned. Earned premium was defined in the Washington Physicians case as that part of an insurance premium which pays for the protection the insurance company has already given on a policy. At the time when the full $2 million benefit under the reinsurance contract was paid out to American Superior, Imagine had no further obligations under the contract. If American Superior had not become insolvent, had not entered receivership, Imagine still would have had no obligations under the contract. It could have waited out the remaining 9 months and would have been entitled to collect the $900,000 of premium. If 5 more hurricanes had hit, Imagine still would have had absolutely no obligation under the contract because the $2 million was all that the contract provided for. Now, something else that the receiver points to.
Before you get on to another point, you obviously interpret what is the language?
Lost payments shall be offset against any outstanding
due for the
premiums
contract year.
Right.
You obviously interpret that to mean premiums that will have been due by the end of the contract year.
Yes, I think the term.
But isn't it an equally, you keep saying plain reading, but isn't it an equally plausible reading of this to interpret the word due? When I think of what is due, for example, I think of what is owed right now. Isn't that an appropriate interpretation of it as well? I mean, that's sort of what the trial judge did. Said, well, there were no premiums due. The only premium that had fallen due by that time had been paid, so there were no premiums due. Why is that not a plausible interpretation of the contract?
Because I believe it reads words into the contract. I think if the parties, obviously sophisticated parties, had intended for that provision to mean any payments that had already become due, in other words, payments that were past due.
But they might argue due for the contract year to interpret that to mean premiums that will have fallen due by the end of the contract year, never mind if the loss occurred in the first quarter of the year, is reading words into the contract. I mean, they probably say the same thing about your argument.
They may, but I don't believe that's an appropriate interpretation. Due for the contract year, if I have an auto loan and somebody asks me how many more payments I have due under the loan, I would interpret that as meaning any payments that I have due until the auto loan is paid off. In this case, outstanding, we know what outstanding means. It's defined as unpaid or continuing to exist. Outstanding premium installments due for the contract year, I think you have to interpret that as meaning installments that continue to be due for that contract year. And I believe the provision contract year is important there as well. If the parties had intended for it to mean only payments or only premium installments that were past due or that had already become due, I believe they easily could have said something to the effect of lost payments shall be offset
Well,
against.
doesn't reading it your way make the word due superfluous? Because they're not due. Why didn't they just say premiums for the contract year? Then it would have been clear that we're talking about all the premiums that will have fallen due by the end of the year, not just those that are now due. The word due in there kind of bothers me because it suggests that something is owing and immediately needs to be paid right now, not that it will have fallen due. You're interpreting the word due to mean will have fallen due by the end of the year, which is kind of an odd interpretation, isn't it?
I believe reading the provision, I think that's the appropriate interpretation. Due, if they had not included the term due, I think there would have been ambiguity as to what premiums are due. Obviously, some premiums could have become paid in the normal course of business, normal course of the contract, prior to a lost payment being made. I believe by putting the term due in there, they were clarifying that all that needed to be offset were any premium installments that continue to be due for the contract year. The receiver argues in the alternative that the $630,000 that was offset was avoidable transfer. I don't believe it's avoidable transfer for three reasons. First, the avoidable transfer statute only permits preferences to be voided. Second, if anything, the $630,000 was a valid offset. Offsets are permitted to be made among reinsurers and insurance companies. And the offset statute, by virtue of this very court's own case law, has to be an exception to the voidable transfer statute. It would make no sense to allow an offset under the voidable transfer statute and then say that that valid offset could be recovered, or to allow an offset under the offset statute and argue that that offset could then be recovered by virtue of the voidable transfer statute. This court has held that by its very nature an offset is a species of preference and must be an exception. Third, Imagine was a bona fide holder for value. At the time that this contract was entered into and at the time that this agreement was negotiated, Imagine and American Superior were at arm's length. It was an arm's length transaction between sophisticated parties in the normal course of business. This was a negotiated for contract. Each party had a benefit they could obtain from the contract. The receiver argues that in some respects that it's unconscionable that this contract would only provide $141,000 worth of reinsurance. But if we look to the actual terms of the contract, $141,000 is what was contracted for. Imagine, to protect itself, negotiated the contract to provide $2 million worth of reinsurance, and in the event of a loss, part of that $2 million would be paid back. Its maximum loss under the contract would be $141,000. I believe that's clear under the contract that was the maximum amount to be paid. It helps to look at the maximum upside to Imagine to determine why that $141,000 was the maximum loss. The maximum upside in this contract was only $270,000 to Imagine, less the costs that Imagine incurred by entering into the contract, and if a loss was made, floating $2 million worth of benefit to American Superior. So on the one hand, some amount less than $270,000 was the maximum benefit to Imagine, and on the other hand, the maximum loss was $141,000 plus the cost of contributing this capital to American Superior. Clearly, it's a reasonable contract that was negotiated at arm's length between these two parties. I want to touch on briefly the non-renewal charge. Imagine part of the contract term, as I mentioned earlier, was a profit and loss sharing arrangement. This contract was not intended to be canceled after 1 year in the event of a loss. Clearly, Imagine knew that it would have suffered a tremendous loss if a loss payment was made and it was canceled after 1 year. And the $270,000 that would have been retained by Imagine was in no way fair value or would not have been fair value under a traditional reinsurance contract. In this case, the plain language permitted that upon special termination, which is what happened here, the special termination clause permitted Imagine to cancel the contract or to terminate the contract if American Superior became insolvent or entered receivership, stated that upon special termination, commutation shall occur in accordance with the commutation article. If we look to the commutation article in the contract, it required a $959,000 non-renewal charge in this case, and that was pursuant to a formula that's included in the commutation article. The plain language of the contract requires payment of that non-renewal charge. The only issue here, as the receiver argues, and the only issue not addressed by the trial court, is whether that amount would be avoidable transfer. It would not be avoidable transfer again in that case, because
the receiver also argues, and I may not fully understand their argument, argues that the date the insolvency proceedings are initiated is the date by which Imagine's claims must be perfected. And I believe it argues that that date is September 29. Is that correct, or is the date December 15, which is the date of the later order?
Well, I believe the claims have to be perfected as of the order of liquidation. But in this case, I don't believe, as far as the non-renewal charge is concerned, I don't believe it's even an issue, because there was a trust account that was transferred back in July of 2004 that was solely for the benefit of Imagine. I believe the avoidable transfer issue in that case would be whether the transfer of the trust assets to the benefit of Imagine, with Wachovia as the trustee, whether that was avoidable transfer back on July 1st of 2004. At that point, value was given. Imagine would not have entered into this contract but for the transfer of the trust assets. That's clear from the contract language. Both parties agreed that it was a material condition to the contract. And the trust assets existed solely for the payment of Imagine. These trust assets, trust funds, cannot be pulled back into the receivership under some argument that they remained owned by American Superior. By virtue of the trust itself, equitable ownership was in Imagine, and the trustee had legal ownership. American Superior had absolutely no ownership of these
But American
assets.
Superior had some rights, because wasn't a return paid to Americans, or to be paid on the assets in the trust?
It had certain rights. It had the right to vote the shares contractually. Had the right to vote certain shares in the trust and to receive interest under the trust. But its right to actually recover the corpus of the trust was contingent. It was contingent upon all of the obligations in the structured reinsurance contract being discharged. I see I'm into my rebuttal time. Thank you.
Good morning. My name is Helen Hauser. I'm here on behalf of the receiver, which is the Department of Financial Services. This is a situation in which the insurance insolvency statutes functioned exactly the way they're supposed to, and you have a correct result. You have a party who was intimately familiar with the serious financial problems of American Superior, entered into a transaction knowing about those problems, everything about the transaction, even if you go back to the retroactive date, happened less than 4 months before the first successful petition for delinquency was.
I know in your brief you make a great deal out of what I call sort of an assumption of risk that Imagine has here in entering into this contract with an insurance company that was in some financial difficulty. But isn't that exactly why they structured this reinsurance contract the way they did? Because they knew. And I think, wouldn't any reasonable reinsurance company go into this trying to protect itself every way it possibly can? And could the state even think a reinsurance contract wouldn't be structured like this, given the nature of this insurance company?
Well, there are two principles that need to be addressed in answering your question. The first one is you have to separate the regulator from the receiver. And if you look at the Blackburn cases, both the state and federal bankruptcy cases that are mentioned in our brief, it explains that. So whatever the regulator approved or okayed, and in fact, whatever the company approved or okayed, is not an estoppel for the receiver. The receiver's rights are created by the insolvency statutes in Chapter 631.
But if we look at this contract, reinsurance contract, as a series of mutual obligations,
Right.
doesn't that trigger the exception to the preference provision?
Well, the bona fide holder for value definition, which was placed into this statute in 2002, which, by the way, is after nearly all of the other cases that are cited, and is very important because it's not in the Bankruptcy Code, it's not in the Model Act, it's a provision that's unique to Florida, and that was put into that statute by the receiver, essentially by the department at the time. And it talks about a bona fide holder for value and that's 631.011 definitions. It's a person who, while not possessing information that would lead a reasonable person similarly situated to believe that the insurer is insolvent or is experiencing an impairment of capital or an impairment of surplus, and while unaware of the imminence or pendency of any receivership proceeding against the insurer, has, in the exercise of reasonable business judgment, exchanged his or her own funds, assets, or property for funds, assets, or property of the insurer having an equivalent market value. And then we also have placed, at the same time, we define fair consideration to have a good faith component, which means you have to not know about the problems the insurer is having. And we defined good faith, and we defined property. All of those were placed into the statute in 2002. Property of the insurer, for purposes of 631, includes all interests of the insolvent entity, whether legal or equitable, tangible or intangible, choate or inchoate, and includes entitlements that arise by operations of the provisions of Chapter 631. In other words, if there's a way that the receiver can make a legitimate claim to the assets by using the voidable preference or voidable transfer provisions or any other rights that it has under Chapter 631, then the receivership court has jurisdiction over that as property of the estate. It can adjudicate the dispute, and it can determine inequity, which is what this proceeding is, who has the rights. What basically happened here is that less than 4 months of the insolvency, actually less than a month, if you look at when the premium was set off, a reinsurer protected itself at the expense of the other creditors of the estate, which is exactly what the insolvency provisions are supposed to prevent. And if you look at the contract, the court was exactly correct in the interpretation that, first of all, there was no right to do this at the time that it was done. And if there was any right to do it under the contract, the time when that right matured was certainly within the voidability, and there's no question it's within the voidability period, and it can't be a bona fide holder for value because they have always admitted, that they knew that this company would not survive one hurricane. So the second it had one hurricane, there it goes. There's no question that they knew that. So they are not a bona fide holder for value.
But is
on
that
the date when they
experiencing an impairment of capital? I realize that the insurance company would have been in dire straits as it became with a hurricane, but does that fit the definition of it was not insolvent or experiencing an impairment of capital or impairment of surplus at the time these contracts were entered into, was it?
Or the imminence or pendency of receivership proceedings is also part of that.
But the only imminence would have been had there been a hurricane.
Right.
Right.
But in August, which is when they took this set off, there had been a hurricane. And in November...
But the mutual agreement, which was the contract, was entered into, I think, isn't that the time period you have to look at in determining whether or not you're a bona fide holder for value? Because that's the time that you exchange your funds with the
No,
insurance
because
company.
you look at the time of the transfer, and you date the time of the transfer, and that's defined in, I think, 631,
But you're
262, the time of the
Don't you have a
transfer.
set-off exception, and isn't that triggered by the fact that these were mutual obligations?
Well, I'm glad you asked that question, because there's an incorrect representation that the set-off trumps the voidable transfer provisions. That's absolutely not true. They are red in peri materia. If you had a set-off right, for example, in the Barnett Bank case, where there was one of these banking arrangements that the bank has a security in the company's accounts for money that it advances on a letter of credit or an overdraft. It advanced the money. It didn't have any reason to know about any of these problems. It was a legitimate, innocent third party. And therefore, although that might otherwise be a preference, it wasn't a voidable preference. If you have something that happens within the voidability period, and it is a voidable preference, then it's not going to be set off. The set-off provision does not trump the voidability statute. So the fact that there is a potential set-off in the contract, and again, I certainly think Judge Padovano's discussion was correct. When you say due, you mean due. You don't mean that might be due sometime in the future.
But under your argument, that wouldn't matter, would it? Even if we construe the contract the way that Imagine is claiming us to, wouldn't you still be arguing avoidable preference?
Yes.
So, it's with all due respect,
So
sounds
we're
like
right.
a little bit of a red herring.
We're right for two reasons.
This case is either a contract construction case as to that issue, or it isn't.
Well,
I mean, or if it turns on the contract construction, then we need to either go the way the circuit judge went or the way Imagine wants us to go. If it doesn't turn on contract construction, as I think you're arguing, then it doesn't really matter.
you're correct. It doesn't really matter. But the reason we're arguing it is that the judge did not specifically reach the voidability argument because he hung his hat on the contract interpretation, which I think was correct, and he didn't need to go any further.
Under your argument, though, the voidable preference or not has to be adjudged as of the time that these two parties had their commercial dealings in the spring of 2004. Is that right?
No, it has to be adjudged at the time the transfer was made.
See, the problem with that argument is if they're right about contract construction, it would require ASIC to breach the contract.
No, because at the time the transfer is made, there are two different problems. If you look at the set-off of the premium that they took in August, their argument is our right to set that off arose when we paid our $2 million.
By virtue of the contract.
Right.
Okay.
But for purposes of the insurance insolvency statutes, a transfer is made when nobody can get rights at property that would supersede the rights
I
of the
understand that,
transferor.
but I still suggest that under your construction of the insolvency code and under their construction of the contract, they would have to breach the contract to comply with your instruction, your construction. If they're right, now, I don't know who's right about this due during the contract year part, but if they're right, they would have to breach that clause because they could not take the set-off.
I believe they were not entitled to take the set-off, but they would have to
So
pay
their contractual rights were fluid after the contract was negotiated, sealed, and signed in May of 2004.
No, as to the premium payment, they were going to get their premiums throughout the year in 4 installments.
Well, that's a good question, too, because once the maximum loss is paid, why would they pay any more premium?
We would be owing the premium.
Leaving the insolvency aside.
Right, we owed the premium.
Once the loss is paid, why would they pay any more premium but for this clause?
We were obligated to pay the premium over 4 installments.
Why would you pay it, though?
Because if we don't, we're not getting reinsurance for the next year.
I guess that's true, and I think all of us are probably going to struggle with this construction, but it does occur to me that under your argument as adopted by the trial judge, there doesn't seem to be a whole lot of incentive to pay the rest of the premium once the loss is paid.
Well, we have to, otherwise we're never going to get any more reinsurance. Assuming
So
you did not,
to be sure I understand this, your argument is that, say, had the company not become insolvent and the reinsurer had paid the full amount of the insurance policy, $2 million in the first quarter, let's say, the insurance company would still owe the remaining premium payments for that quarter, even though there was no way, had there been another hurricane, that they were getting any more money from the reinsurer.
they have to pay it out over the course of the year.
So
That's
this
what
in
the
your
contract
view,
says.
and just see if I have it right, is a matter of contract, and the reinsurer could sue the insurer if the premiums weren't paid.
If they don't get paid when they're due, yes, there's a contract right to pay them. But if the policy gets canceled, ordinarily you owe, it's not due yet. So it's not due yet. You might
what
have a
about-
claim for it in the receivership. If you sued us in contract and said, well, wait a minute, I'm entitled to the rest of this anyway, which they never actually made that claim in the receivership, but I believe if they had, it would be, if they won it, it would be a low priority claim. It's not, they can't take it as a set-off because it's money that might be owed in the future.
Well, what about counsel's argument, though, that if, and we have discussed some differing possible interpretations here, but they argue that if you don't interpret it to mean the premiums for the entire year, that renders the phrase for the contract year superfluous. What meaning does that have if it does not mean that you are to include the premiums for the whole year?
Well, this is supposed to be a 3-year arrangement. So I think what it says is that you can only look at things that were due. If you pay the loss in 1 year, you can only offset the premiums that were due and owing in that year. And if there's something else from a prior year.
That's what they want to do. They want to offset the premiums for the whole year.
But
And you want them to offset only one of
only
those.
the ones that are due.
Well, that's my point. Why did they say for the contract year? What is that
And my
phrase?
point is, because they mean you can't consider things from other years. You can't consider any obligation from a prior year or a future year, but only from this year.
So your interpretation of this is it has to be due, meaning that it's presently owed, and that it's limited to only those that are that apply in the contract
Right.
year.
And if you look at the word due,
Well,
it's
ones in
used.
subsequent years wouldn't be due under any case, would they? I mean, that would, their argument is that putting the
Essentially,
phrase.
they are, because they're trying to get this non-renewable clause, which is basically the premium for the future year, but
that's another
there could be from prior year, because it's supposed to be a 3-year arrangement. So when you renew it, if you have something in year 3, and there was something in year 2 that wasn't paid, then.
But your reading would have the clause read installment then due.
No, due is defined in the contract in several places where they talk about where a payment is due, and they talk about if there's no other definition, it's going to be due 30 days from the date when there's demand made. So they have definitions of due, and they have a penalty, which is an interest penalty, for things that aren't paid when they're due. So if you look at the contract as a whole, it tells you what due means.
Your reading would also, it seems like, severely impinge upon the rights of, not the right, but the ability of a small insurance company to negotiate reinsurance. Because the upshot of what you're arguing, if I might suggest this, is that no reasonable reinsurer would offer an installment insurance contract. Because under your view, the loss occurs on June the 1st. That's just the way it goes. It's easy to see why an automobile insurer, a normal casualty insurer, fire insurer, someone that's issuing these HO2s would offer installments, and they all do. It's not quite as easy to see why a hurricane reinsurer would do it, but for their right to recover the unpaid installments, and I'd like you to respond to that.
Well, they have a right to recover the unpaid installments as long as there's not an intervening insolvency. The insolvency changed everything.
That really doesn't speak to the concern I'm trying to raise, which is that it seems to me that if we go down that road, what it says to companies like Imagine is you can, if you're dealing in Florida with a small insurance company, given the erratic nature of our, and unpredictable nature of our hurricane experience, you can really only sell these contracts if you can find a company that's able to pay that premium on day one. Because you're at risk of not ever getting paid.
They could have written this to say that if we pay the loss, it's automatically due, regardless of what time it is. So they could have written it that way if that's what they meant.
That way. That's the issue.
And it still would have operated that premium would be paid throughout the year, but for the insolvency. Insolvency changes everything. And when you write an insurance, when you contract with an insurance company in Florida or any other state, those statutes are incorporated into your contract.
And that's the other issue I wanted to raise earlier in your argument. Illiquidity is a phrase that we've become very familiar with, and it strikes me that the department's argument in this case would promote illiquidity of a nearly liquid small insurance company, because the very fact that you're saying should have put them on notice is the reason, number one, that ASIC required reinsurance, and number two, why they negotiated this contract.
The situation really is a question of who loses. And that, if you read 631-001, the purpose of the insurance liquidation statutes is to equitably apportion any loss and to provide priorities. And the priorities are the policyholders come first. And in an ideal world, yes, this reinsurer would have been paid back. But there was an intervening insolvency. So now, who loses? And our public policy dictates that the party that was better able to protect itself...
But answer my question, though. The specter of insolvency has to be on everyone's mind in dealing with Florida casualty insurance, at least now. Doesn't your argument mean that these folks sitting in their offices in Barbados or wherever they are going to have to do things completely different? Because if they're dealing with a marginal insurance company, they're going to have to make a business decision. Don't help them out on reinsurance, let them go down, or help them out, and the risk is they'll be insolvent and we won't ever get this money back.
That's the risk they took, and they went into it with their eyes open, and they knew it. And I need to address the non-renewal premium issue also.
Address the question. I mean, it seems like this case floats around a lot of different orbits, and there's easy ways, there's sort of straight line, some might say simplistic ways of looking at it, and there's more complex ways of looking at it. But on this second point, let's talk about the nature of this trust account. If this is a true trust account, and it seems to be if you look at the trust agreement, I mean, there's been an alienation here. There's a legitimate corporate trustee, and there is one designated beneficiary.
Right.
Why is there any property interest at all retained by the transfer or the settlor of this trust account? Because
if you look at, again, the definition of transfer, the transfer occurs when the rights are so far perfected that nobody can obtain a right that's higher. So this is contingent right. They can't collect on it until there's a default. There has to be a default. They have to make a demand. There had not been a default at the time of insolvency. Once there's a rehab order, everything freezes, and that was in September.
Well, you would still have to persuade us, as you persuaded the trial judge, that $1 million is part of the insolvent estate, wouldn't you?
Well, if you look at the definition of property, it is. It's property to which we have an equitable or a legal right, or a right that can be a right that is created through the voidable transfer provisions.
Doesn't the contingency run the other way? Isn't it the insurance company that has the possibility of having some of that money back down the road? They have paid over, and the trustee has legal title, and Imagine has beneficial title to the assets. And the contingent interest, it seems to me, is in American Superior.
But Imagine can only take the money if there has been a default, and there was no default prior to the time when everybody's rights got frozen. Because the right to recover this non-renewal premium doesn't happen until somebody cancels the contract, and I don't think that it happened even then, because...
But I thought December 15 was that date.
No, December 15th was the liquidation date, but there was a rehabilitation order on September 29th which froze all rights and had an injunction that said nobody can take any action to perfect any rights in property against property of the insurer. And property of the insurer includes things that it has equitable or contingent rights to. And so and that's why Imagine didn't take the money at that time, because everybody's rights were frozen then and they were not allowed to do it. So unfortunately for them, they did not have a perfected right in that trust account. And I don't think they ever had a right to take the non-renewal premium anyway, because the non-renewal premium is a penalty if we don't renew, which is not what happened. And there was no commutation, which is another thing that could give a right to it.
Wasn't there a commutation by virtue of the terms of the contract?
No, what the contract says is if Imagine terminates, the parties are going to now look at the commutation clause. So within 30 days, they're supposed to get together and commute.
Well, that depends on which part of the commutation clause, respectfully, is triggered by the special termination clause. There seem to be several different sentences. We've taken a good bit of your time, but you are a little bit over.
I know, over, yes. Okay, thank you.
Thank you. We'll allow rebuttal.
Just a few quick points here on rebuttal.
Touch on that perfection date again, because that's why I asked you which date triggered this. And the department's position is September 29, and your I guess your notice was after that date.
Well, I believe that December 15th, the order of liquidation, it is the important date there. But because the trust account, as you stated, the trust account was the property of Imagine. Imagine was the equitable owner, at least, of the property. The trustee was Wachovia. The trust funds were not property of American Superior. So I don't believe it's even relevant when Imagine's claim to the trust assets were perfected, because if anything, all that could have happened after that time was the contingency not happen and the funds be returned to American Superior. But from the moment that those funds were put into a trust account, I think the receiver would have you read trust accounts as irrelevant.
What's the source of payment in case of commutation with a positive experience account? What's the source of payment back to ASIC?
Just from, I don't believe there was a trust account set up. It would have been Imagine. Imagine,
they
which
had to
was,
trust you. You secured yourself, but they had to trust you on the others.
Well, and for good reason there. I mean, Imagine, obviously nobody's, to this point at least, nobody's ever been worried about Imagine's ability to function. It's a highly capitalized reinsurer. There was a purpose for the trust account here, and that was because American Superior, was having some financial problems and was working through it, and that's why this reinsurance contract was entered into. American Superior actually sought out this reinsurance contract. It was encouraged to seek out this reinsurance contract, according to Benfield, by the Florida Office of Insurance Regulation. This is not a case where Imagine sought out an insurance company that was having financial difficulty to try to pull money out of an insolvent insurer. If the terms of this contract are given effect, Imagine still loses $141,000. This is clearly not a case where money is transferred from an insolvent insurer to some other party. I think the real issue here is whether the mutual obligations that are included in this contract are given effect. The receiver would have the contract be rewritten to where the only obligations were on the part of Imagine to American Superior, but delete all of the obligations from American Superior back to Imagine. And as you pointed out earlier, doing so would send a signal to the reinsurance market: don't do business in Florida with any insurance companies that could even remotely have a chance of
well, I
becoming
think really
insolvent.
what they're saying is that insolvency is a cut, and any obligations by American Superior that have to be performed after the date of insolvency don't have to be performed by virtue of the insurance code and the insolvency provisions.
Well, and there's nothing in the insolvency code that says the contract can be rewritten. It says that the receiver can void certain transactions, void certain transfers, but there are specific principles that need to be followed there. If the person is not a bona fide holder for value, or if there's not a valid offset, or if there's a preference. In this case...
But the revised definition of bona fide purchaser for value, the department argues, fits this case in that you aren't a BFP under the statute.
And I don't believe that's correct. I think at the very least, whether they had an impairment of capital, an impairment of surplus, or whether they were going to imminently enter receivership, those are statutorily defined terms, and I believe that requires factual determination, which was not made in this case. If anything, if the receiver was to win on the voidable transfer argument, I think there needs to be a factual determination as to whether whether capital was impaired or surplus was impaired, and whether Imagine had any knowledge of that. Clearly here, American Superior had some financial difficulties, but by entering into this reinsurance contract, it was attempting to work through those issues, and the Florida Office of Insurance Regulation was cognizant of that, according to Benfield. Let's see, my time is up.
Did the circuit court decide this case solely on contract grounds, his construction of the contract?
Yes, it did, Your Honor. The circuit court did not address voidable transfer at all.
At its most basic level, your argument is that's the way the case, you agree that's the way the case should be decided, but because we have de novo review, we should disagree with the circuit judge.
Yes, Your Honor. I believe the plain language, is clear, but I believe it's clear the way that our client has interpreted it and the way that I believe the evidence, assuming that it was not clear. At the very least, there are two interpretations, and we would have to look to the intent of the parties, and the intent of the parties, I believe, is also clear in this case.
Thank you. We'll take the 10-minute break and resume with the